Welcome to part 3 of our Living Library segment on land use. I'm here with John Foote and Ben Leigh, and we're going to have a great conversation about what it's like to be a land use lawyer. Why don't we start with some introductions, and perhaps you can tell us how you got into land use law. Let's start with you, Ben.
Well, Karen, I practice in Leesburg, Virginia, and Leesburg is a jurisdiction that has changed rapidly. A few decades ago, it was a rural community with dairy farms, and now it is a bustling community. And so my everyday real estate practice has a lot of land use in it, and had a lot of land use in it from 20 years ago, and you almost had to get into, how do I get this special permit? How are we going to cut up this piece of land? What is happening with this parcel next door? So it became something that is an evolution of my practice, but it also is woven into so much of what we are asked to do as real estate lawyers. When someone says, well, I've got this piece of property that I want to sell, and the developer's going to take it through the rezoning process, what happens? What's going to happen to us as we go through that process? And so it's really a natural evolution, but it is something that makes your practice more interesting.
What about you, John?
Well, I'm like you, Karen, in that I did not start off as a land use lawyer or even a private lawyer. I started off after I got out of law school at the Department of Justice, where I was a criminal lawyer. Was criminal appellate, but then within days I literally got transferred to the White House staff. Completely unexpectedly to me, and I'm sure to the White House, where I worked on President Ford's clemency program for Vietnam-era personnel. And then after a period of time, I got a phone call from the person that had just become the new county attorney in Prince William. And he and I were law school classmates. He invited me to join him as his deputy, and for the next 12 and a half years, I was first the deputy county attorney, and for 7 years the county attorney in Prince William. And as a consequence, I learned my land use law as the county attorney and began writing the chapter on planning and zoning at that time, and becoming active in the local government attorneys of Virginia. And when it came time to go in private practice after that 12 and a half years, nobody wanted to hire me for my expertise in personnel law. I got hired because I had background in land use. And so I went first to a firm that became Hazel & Thomas, where I practiced land use all over Northern Virginia and did lobbying as well. And then 25 years ago, I joined Walsh Colucci, and I've been doing land use in the Washington area and to the Valley as well for the last 25 years.
That's so interesting that you started in criminal law.
I did.
And then, of course, there's that intersection with the local government law that I talked about earlier, and they really are kind of hand in glove with land use and local government law.
Oh, it's inescapable.
Yeah.
Absolutely inescapable.
Yeah. Well, what would you say, we'll start with Ben, what would you say is the most important advice you could give a new land use lawyer, or even this living library is sort of meant to for experienced practitioners who maybe haven't really done land use but are thinking about it?
I would start off with know your jurisdiction and its particularities very carefully. You need to work with a team that has experience in that jurisdiction. If you say, in some jurisdictions, well, in Fairfax they do it this way, you have moved the ball backwards. That really does matter in terms of land use is local, land use is politics, but it is something that your jurisdictions are very proud of in terms of their processes and procedure. So again, you need to work with a good team that knows what they're doing, and you then have to be the quarterback of that team to know when someone may be off kilter.
I would absolutely concur, because I think both of you probably heard me say this. I know all the technical rules. There are really only 3 rules of land use. Rule 1 is, do you have one more than 1/2 of the votes from the governing body? Rule 2 is that A lot of land use is completely irrational. And Rule 3 is see Rule 1. Do you have the votes on the governing body? And what that constitutes is an understanding of the political framework of whatever you're doing. And if you're going to be really good at it, it means, in the words of one of my partners, you have to know not just the general politics, but the political subtext of things, because to get those votes in a difficult circumstance, and I've said before that what land use lawyers often do is sell the unwanted to the unwilling, because you're coming in against opposition, you're coming again in where there are agendas that you will never be told about, that you need to understand how that process works. I have gone into jurisdictions where I did not know everybody because I do so much work in outer jurisdictions, all the way down to, I've gone into Lexington before. I've practiced in probably 20 plus Virginia jurisdictions. And it is nerve-wracking because you always expect the unexpected. Well, if you go in, you can't even expect the expected if you go into a jurisdiction where you don't know. So I would emphasize that for understanding not only the rules and regulations, because despite the statewide legislative process we have, every jurisdiction has its administrative and political quirks.
And then to kind of round that out, John, the thing is you do not really have a great shot after you've gotten a final vote. This is not something where you get a trial de novo from a circuit court judge.
We will talk about that in a moment, I'm sure, because that is absolutely true. Get your votes. Rule 1, Rule 3.
So there is that political aspect that you have some control over, but that's also a little bit out of your control from time to time, right? But in terms of more practical things and the law that you do need to know, what would you say is the most important kind of legal principles and legal rules that you could kind of tick off for somebody?
One thing, John, I would jump in and say always know your boundaries. And an ordinance sometimes is treated like Magna Carta, and it is not necessarily Magna Carta, and you've gone over that in your earlier presentation. We have the Dillon Rule, and so the county or locality is not unlimited in what they can do. So oftentimes you have some applications that have issues that are on the edge, or maybe even have aspects that are outside the zoning ordinance. What if you're doing a farm winery? You have a state enabling legislation. What if you have a house of worship? You may have RLUIPA issues. Then you have all those constitutional boundaries where you have to know when someone is making an exaction that may implicate Nolan or Dolan or St. John's. So those specific aspects have to be within your framework. Then I think I would turn it over to John to say, then you've got to work through the particulars of an application.
Yeah, it emphasizes what you said about the framework not just being 3 statutes. The framework is everything Ben just talked about. But the other thing that you have to start off with is there's an application. And that application is not a simple question of taking a piece of paper and checking the boxes off, because they will frequently ask you to make sure you've got a sufficient narrative statement. What are you applying for? They'll want your environmental constraints analysis. You'll want your survey. They will want your traffic analysis. And so what we constantly work on and what we constantly hear from staffs is that application was inadequate or incomplete. And we pride ourselves on making sure that what we send in at the very beginning is in fact a thoroughgoing application. We have checklists. We make sure those checklists are complete so that when the application goes in, we don't get it rejected because something's missing. And we care about the narrative statement. Some people just fill out a piece of paper and say, oh, we're looking for 125 houses down Easy Street. No, we say why we're looking for it, and we say what that's going to have as an implication politically, or not politically so much as a planning matter, because plans used to be more generic than they are now. Some jurisdictions, including increasingly Prince William, they're parcel specific as opposed to being generic.
Yeah, I agree with you 100% about having a complete application. Sometimes you will hear some people say that they use it strategically to skimp on the application and say, let the staff come back and ask us for more. And that's not a philosophy I really believe in. I, like you, think it's important to get a complete application in. And in fact, I mean, part of that is showing staff too that you're not someone who's playing games with staff, and you're treating them with respect by giving a complete application.
But at the same time, where you do have to work respectfully with staff, staff is not divine. Your votes are going to be made by others. And that is who you're gearing the application toward, John.
You are. But you raise a point about just simply mentioning staff that you and I have talked about many times before. And that is that a lot of people in the land use world, I think, that aren't really sophisticated in it or haven't been in it long or have been in it too long, they tend to treat the staff with disrespect and ask them why they're doing what they're doing and get angry at them. And our experience in many jurisdictions, and it's not just Prince William, Fairfax, Loudoun, these people are generally trying to do a good job. They've got an ordinance to administer, they've got a staff report to write, they've got people they react to and respond to. They answer to the planning director, who answers to the county administrator or county executive. They're trying to do a good job, and if you treat them with the kind of respect to which they are entitled, it tends to be very reciprocal. Absolutely. But I've seen it go wrong for so many people. It's like a judge once said to me after he saw who was up next on his docket, he said, "Oh my God, not him." So it's the same thing. You don't want to be that guy. You don't want to be that law firm.
Right.
But at that same time, though, John, you have the ability to agree to disagree respectfully, and there's a season for all things, and so there may be a time.
Can I quote you on that?
You can. I think someone else has said that.
Yeah, I read it before.
Yeah, Bill Shakespeare, some guy.
I thought it was God.
Yeah. There is a time, though, to challenge a zoning administrator's position. There is a time to maybe challenge a staff position on an issue, and that can be done respectfully and forcefully.
And it can be done more easily if your relationship with those people is one of mutual respect, and not if you've been hostile your entire practicing career. And because we work in so many jurisdictions, and you're on a first name basis with the zoning administrator in 7 or 8, 10 jurisdictions, it's a very different thing than calling up somebody you've never seen before. But even if you're only working in one jurisdiction, that rule still applies.
But I think that's an excellent kind of segue to a point I made earlier, where your staff is used to treating the ordinance as this preeminent document that exists in and of itself. Many times they have not had the opportunity to work through something where maybe there's a prior determination that's been made that this is a thing decided. Maybe there is even a mistake, but too bad. 15.2 2311C tells us this may be something that is now vested. Right. Staff has to have the opportunity to have that presented to them.
And we've been known to do that, haven't we? They are sometimes wrong. Sometimes the staff misinterprets. Sometimes they choose an interpretation that you can't abide because you think it's wrong. And the way you get to a solution to that, nobody goes to court over these things, or necessarily into the BZA. It's too costly for your client, because to go to court now, we'll talk about that in a while, it's way too much time involved. So you must resolve that problem as opposed to fight that problem. And I'll also say that one of the things that both you and I have done in our day is, if the rules don't work, change the rules.
Right.
Yep. Yeah. Well, definitely the golden rule applies, right? Treat others as you wish to be treated. So,
can I write that down too?
Well, we've got the whole cliches going, don't we? Well, all right. So how about let's talk a little bit about kind of everyday practice and maybe some examples of, we'll hide the names to protect the innocent, but let's talk about maybe some specific case examples. I know, Ben, you are in Loudoun County, where there's lots of farmland,
Allegedly.
And, yeah. So you probably
We
deal
have
with subdivision.
opportunities all the time where someone is presented with or even looks into, what can I do with this larger piece of property? And the issues are not as simple as, gee, I want to cut it up into one or two pieces and the county should have no issue with that. It is oftentimes we're going to look at things like an ag district, whether you have tied the property up for a certain time period where you're not allowed to subdivide it unless you have extenuating circumstances. You may also have the unfortunate opportunity to find out that what you thought was the zoning, the family thought the zoning was this, and they've waited around for a while. The zoning has now changed, or an overlay district has now been imposed on them. So it's not as simple. Again, your great example of I have a permit. It is the same thing as we don't just have a piece of paper and we X out a couple lots and go over to the county. It is not that easy anymore.
Yeah, and when you talk about zoning changing, and I didn't cover this extensively in the first part of the presentation, but alluded to vested rights. But that's another thing that's often important to communicate to your clients, is that you don't have any vested right to zoning. So what you bought the property thinking you might do one day does not afford you any vested rights. And sometimes people have a hard time with that.
That is correct.
But, it's real estate. So if you now can't do what you thought you wanted to do with it, you can sell it.
Well, we also see, and it goes back to the comprehensive plan question you were talking about, when I get called up by someone and say, I need you to help me run through what this property can be done for, it could even be a very sophisticated potential purchaser or someone who has gone into contract, didn't call first. And you say, well, all right, well, we have 14 different overlay districts. And are you in the mosquito overlay district? Are you in the wildfowl overlay district? Are you in the historic overlay district? Are you in one of our 4 highway corridor overlay districts? Well, let me look it up for you and tell you. And they go, what are all of those and what can they do to me? And the answer is sometimes what you thought you could do and what you could have done before these were adopted, you can no longer do simply because you know the votes will not be there, rule 1, because the board has already said, we don't want that there for whatever. Oh, and the airport overlay zone.
On the mountainside.
The mountainside
overlay.
zone, the karst district. Because, well, for good reason, we found that you build in the karst district tends to sink into the ground. Yeah, there's
and that is
problem.
perceived as a public problem.
It's perceived as a private problem for those who are on the karst district as well. We have a place out in Berryville where they were trying to do the stormwater management on that piece of property, and they discovered that the water did not run to a stream, it disappeared underground.
Into a sinkhole.
Into a sinkhole. No one knows where it goes from there. And our engineer says, it's great, best stormwater management program I ever had. We don't have any stormwater management.
I think another common issue that you alluded to again is this idea of I have a structure or I have a use and I can just change it willy-nilly. And that in the transactional context is a real opportunity for disaster. The great example is a wonderful Piedmont, Virginia barn that we're going to now change into a wedding event venue. You have a host of issues. Even if you are trying to tie it to a farm winery, you still have building code issues, you may have private covenant issues. But from a change of use, you even have, one I run across all the time is, oh, this building's historic. We don't have to conform to this, that, or the other, particularly the ADA. That's just not right.
Right. If you're expanding the use, you might lose the non-conforming status, which probably we ought to say at this point just something about non-conforming uses, non-conforming structures, that non-conforming, if somebody doesn't do land use law, right, non-conforming, it sounds like a bad word, right?
Right.
But if you are the person that's trying to hold on to the use that's already there, it's a good word. It's I like to always use the adjective or as an adverb, lawfully non-conforming, right? So it's lawfully non-conforming. So that means you can keep doing what you were doing, notwithstanding a subsequent change in zoning, right? Of course, from a land use perspective, though, nonconformities in the law are viewed negatively because they interfere with this comprehensive plan notion of planning and visioning for the future. If
But
you're going to
there's
have
this
stuff
there's
laying
this
around.
common understanding out there on the street that if it's been there a long time,
Right.
it's okay.
Right.
That's not the test.
Right.
The test is much more
Exactly.
sophisticated.
Yeah.
And with non-conforming uses particularly, I will tell you that when I moved to Prince William County, the population was 133,000 people, and now it's about 500,000. And we have a lot of non-conforming uses, and I have never seen one disappear. They're still non-conforming. Now they've been torn down and become something else, but those are the only ways that they disappear. But I'm sorry, but the other thought you raised in my mind a second ago was the mention of historicity. The most powerful zoning tool in Virginia is historic preservation ordinances, because they actually give the locality the ability to prove anything you tear down and anything you put up. Now, there's a way to tear things down because you have to wait a year to do it if you put it on the market for a potential user. But whatever you put up also has to go through an architectural review board, which has no standard whatsoever one can actually point to as to what's going to pass muster with that. So you're at the mercy of discretionary approvals from the ground up.
Is that why you put the vested rights statute after historic preservation? I always wondered why it was there.
Yeah, why not?
Good spot.
Good spot.
Well, so what about looking ahead? Do you see any particular challenges, maybe also tying in a little bit to the types of development that we see now that are causing challenges, such as data centers? Well, you're the Loudoun guy, don't you have something to say about data centers?
We are ground zero in terms
And you're the
of
Prince William guy, so you both have
looking at the issues of how do you deal with uses that have particularized demands. And so the demand is power right now, and that is then causing a lot of folks to ask, well, when do we have enough? When is there a line? So there's this tremendous, it's been really crazy to see how fast the uses in both Loudoun and Prince William became negative.
And it was, I used to say that to discover that you had the site available for a data center was the new gold rush. If you did, all of a sudden property that was worth $10 an acre is now worth millions of dollars an acre. But you ask what's coming in the future, is it's becoming more and more difficult to find a location for data centers. But what that has also done, and in fact it's not just data centers, but land use is becoming more and more contentious. People are becoming more and more sophisticated in the way they fight you in these matters. Staffs are becoming a little more intransigent about some of that. And so finding a location for not just data centers, but other uses that aren't even similar to that's becoming more difficult, because there is a growing resistance out there that we saw in the residential world some years ago, but we're now seeing about other uses as well, even industrial uses. So I see that growing. And I also, and by the way, with respect to data centers, Prince William County has now, as the time we're taping this, we have approved sufficient number of data centers with our digital gateway and what we call Devlin, that if those are built out, they'll exceed the number of data centers in Loudoun County today. So we are the data center capital of the world. But is that a good thing? Because data centers are now finding harder to move there, so they're moving out of Northern Virginia to Central and down I-95 principally. But I see that becoming ever more contentious, along with all the other stuff that we do. It's not going to get any easier.
Yeah.
Is a lot of jurisdictions are facing change, and they don't know how to get to yes for some things. We are so focused on opposing everything that some new uses are coming along. Battery storage is a
Yes.
great example.
Doing that now.
That is a question of how do you characterize that? How should we do that? But I'll give you a great example. If we lump all this opposition into we oppose everything, and we just had the opportunity to work on an abused women's shelter. Everyone admits that they want this use. No one wants it in their neighborhood. We have to find a way to get to yes for uses like that.
And I'm working on some homes for aging veterans and receiving a great deal of political
All
blowback.
hell.
Oh, yeah.
Right. And that's an issue of looking forward. I think there may be some role for the state as that parent under Dillon to again step in, and maybe we have super vetoes for affordable housing. But affordable housing, we all acknowledge, is a problem. But the morass of regulations and hurdles is part of the problem.
Everybody knows affordable housing is a crying national need, and yet no one has found an adequate solution to the fact that land and materials cost a lot. And how do you make that affordable? That's a struggle that we're going to deal with for, I think, years to
The
come.
uncertain future.
And these questions are not just simply Northern Virginia questions anymore. These questions are hitting Louisa County, they're hitting Orange County, Culpeper, where they have not faced these questions before, and that contentiousness is seeping throughout.
It's a bit of a vexing problem, but I mean, I think I started out when I said with the definition of land use law, I said fundamentally it deals with this tension, right, between private property rights and the good of the community, and things like these needs for power, health, people's health issues, housing, clean energy, all these things that are for the good of the community are at odds with private property rights, and I guess that's what makes it interesting.
Well, it
but
is, because
also makes it quite challenging.
And I don't think any of us that have been in the public sector, as I have been, believe that the public has nothing to say about this. They most certainly do, because it's not up to us and our clients to say, well, you know, the old joke, well, what's your firm policy? Well, it's to pave the bay. Well, no, that's not what you do. You find a way to deal with the combination of pressures that you're under. Now, I would like to raise one other point, though, about pressure that we're facing here for those people that Ben has just said, or maybe you said as well, and that is you have to win it at the governing body level when you're doing a zoning special use, any legislative approval. One of the things we're also feeling as an increasing pressure, and it's going to have real world consequences, is that if you almost never file suit if you lose anymore for reasons you've already articulated. But we're seeing a lot of citizen suits being brought against approvals now, be that data centers, be that
Houses of worship,
be that they'll pick something that somebody doesn't particularly like anymore. We're seeing that, the missing middle suit, the fact that was actually prevailed upon. But the problem now is you might be able to win those even on demur because of the nature of the claims that are being brought. Some cases yes, some cases no. But getting judicial review of those done is becoming so incredibly extended and time consuming with so much uncertainty that it's having an effect on the ability to get these projects actually constructed. Would you agree with that?
Absolutely, with materials fluctuating, but the issue is the timeline has now doubled, sometimes tripled.
Right.
And your clients can't actually afford to stay in the project that long.
Well, some of our clients are very well heeled, and they could, but for the fact they have contracts that may expire or they have to close on, not knowing the ultimate outcome of the litigation.
But it's not all doom and gloom, right?
No, it's not. We do succeed.
There are wonderful projects,
Yes.
though, that I think that you see, you change communities, and you are proud to see a project that you drive by and you understand you were part of that. And John, you've probably seen a number.
Well, over the course of our mutual careers, all of us that do this stuff, we've all seen things that succeeded even against difficulties. That mosque has been approved. It will expand. Cases that we worked on that seemed like they were insoluble got solved. They got solved by the diligent work of us, with the staffs, with the members of the board who saw the merit in what was being proposed. And as Ben has suggested, and as I know you know, we get to work with some of the most inventive and creative people in this world that work in land use. Wonderful planners, private and public. We work with architects that are exquisite. We work with developers and planners who, yes, they're there working for companies that are to make a living doing this sort of thing, but they are leaving behind them communities, people who will be voting in the next election, people who will be filling the churches, people who will be in the schools, not just as students, but as teachers.
And with a particular nod to your former career of architecture, I would say that architecture can really change the perception of a proposed development. And a great example is some affordable housing units that we have seen that people drive by and don't even understand they're affordable housing units. There's a wonderful development in the Plains, Virginia that fits within the vernacular. It's stucco, it's metal roof, it's an affordable housing development, and it looks like it has been there for 100 years.
And you meet someone who does that kind of work, like probably a mutual friend of ours named Kim Hart, that's what he devotes his career to. Kim is a wonderful human being, and that's his devotion to affordable housing, and he makes it work.
That's fantastic.
So that's the bright part.
That's the bright part. Yeah, I guess we don't want to leave folks with the impression that it's every project is super sexy, right? Sometimes it's just getting a new fuel canopy on the gas pumps at the Sheets, right?
Doing a rebuild of the Sheets, yes.
Rebuild of the Sheets. But I mean, there's some nice looking sheets.
Right. Right.
Yeah, you get, and I've said this to anybody, to Rose, to whatever, that no 2 days are alike for a land use lawyer. It's a wonderful practice. It's one I would recommend to any young lawyer interested in getting to a practice they never considered doing, because it's been more rewarding than you could possibly have imagined when you didn't know anything about it.
Where else can you work in the morning on a winery and in the afternoon on a data center?
Where else can you work on a winery in the morning and go to the winery in the afternoon?
Well, there you go, unless you have a night meeting that night.
In which case, you got to go to the night meeting, yes.
So
there is that.
It's morning, noon, and night.
True enough.
On that note, maybe we...
Thank you very much.
Maybe we better quit, right?
Thank you, Karen.
Thank you so much. I appreciate having this conversation with you.
Thank you so much.
Okay.